If you're a business owner in England and Wales and you're in a dispute, you have my sympathies. They're never pleasant, they're very hard to deal with. We've got 25 years of experience, we can really help you out. First step is to watch this video. Second step, go to the website, book a meeting with us, it's absolutely free. Here we are, we're in a company, you've decided that both of you are going to be directors, both of you are going to be 50% shareholders. You adopted the model articles of association like so many of us do, and you don't have a shareholders agreement. And now you find yourself in a dispute. What's that dispute going to look like? Well, it's going to be two people who can't agree upon how best to run the company, and that's going to lead to some very difficult decisions. If one of you decides to exclude the other from the company, that person may well be taking on personal liability for any of the decisions that they make. Somebody within the business may decide that they've had enough, so what they're going to do is set up a mirror company and start trading through that, undermining the original company. All very difficult, can be very emotionally upsetting, and is catastrophic for the business. So what kind of remedies do you have? What can you use to bring the other party back into line and to save the company? The basic principle here is if you're both directors, then you both have strong obligations to the company. Under the model articles, directors are responsible for the management of the company, but they also have very strong duties to the company set out in the Companies Act 2006. There are 6 main duties within the Companies Act, but the 3 big ones are to work for the success of the company, which means working for the success of all of the shareholders within the company, not having any conflicts of interest or declaring a conflict of interest, and using all due skill, care and diligence when acting as a director. So if you're in a 50-50 company and you find that one of the directors is not following any of those duties, for example, they're not working for the success of the company by completely undermining it, taking money out of the company that they're not entitled to, or trading through another company against the company, misusing its confidential information, misusing its intellectual property, then that person is going to be in breach of their director's duties to the company. You have a way to hold them accountable for that. Now, you're only a 50% shareholder, you're only one of 2 directors, so you can't control the company directly, but you can apply to the court through something called a derivative action. And you will say to the court, I am a shareholder in this company, this person is acting against the interests of the company, so I would like to be appointed by the court to represent the company against the errant, unlawful director. Now that's an application that you have to make to the court. The court will look at a number of factors on deciding whether or not to grant you that status as representing the company. One of those will be, is it in the best interest of the company to do this? But if somebody, a director, is ripping off the company, then clearly it is going to be in the best interests of the company to do this, and the court will therefore appoint you to act on behalf of the company against the director. You can then pursue the director personally for the money that he has taken out of the company, that he has profited from, and that has to go back into the company. It's also very useful if a director is trading against the company using its confidential information, intellectual property. Through a derivative action, you can obtain an injunction against the director acting unlawfully to stop him misusing your confidential information, stop him misusing your intellectual property. There's another way forward as well. As well as derivative actions, there's something called unfair prejudice petitions. Now, in derivative actions, you are applying to act on behalf of the company and the money was coming back into the company. If you bring an unfair prejudice petition to the court, you're acting on your own behalf as a shareholder of the company. And you will be saying to the court, the other person within this company is acting in a way that is unfair to me as a shareholder. Now, if that other person is acting in breach of their director's duties, that's a very strong indication that they are acting in a way that's unfair to you. You also have to show to the court that this action is prejudicial to your interests, that you are sustaining a loss because of this. And if, for example, the other director is trading against the company and the company is losing profit, then that's obviously prejudicial to your interests as a shareholder. So you will go to the court and you will say, I am a shareholder, this director, he's acting against my interests because he's breaching his director's duties, and he's causing a loss to the company. Dear court, can I have either an order that he buys my share out at a fair value, which will take account of all the money that's been lost from the company because of his actions, or can I have an order that I can buy his shares out at a fair value, which also will take account of the amount of money he's already taken? The remedy under an unfair prejudice petition is at the discretion of the court, so there are other remedies available, such as changing the constitution of the company, amending the articles, but a share sale order is the most usual order given by the court. So if you're in a 50-50 deadlock company, you're both directors, you're both shareholders, it is a very difficult situation, but there are ways through it for you. One, as I say, is to bring a derivative action so that you can act on behalf of the company against the person acting against that company's interests, or you as a shareholder can go to the court with an unfair prejudice petition so that you can get the full value for your investment in the company, or you can take over the company by a forced sale of the shares.